Hey guys, welcome everyone. Delighted that you could join us today for our HR webinar. So we have an action-packed agenda, so I'll keep things moving. We have three speakers lined up for today. We have Ken Fernie from our partner Quinix talking about trends in the retail workforce. We've our resident HR expert Tommy Smith joining us for an update on current HR topics and issues that are with us at the moment. And we have Robert Dooney from our partner Sherwin O'Riordan talking about non-compliance with face masks and how to deal with it from a legal perspective, which should be quite interesting. If you have any questions, feel free to pop them in the Q&A box and we'll hopefully get to them at the end. If not, we'll follow up with the answers afterwards and we'll make sure they're all answered. So without further ado, over to Ken. We'll bring Ken on there and we'll let Ken share his screen there now as well.
Thanks very much, Keelan, and I'll do the most popular phrase probably of 2020 and 2021. Can you all see my screen?
Yeah, looks good, Ken. Looks good.
That's great. Thanks a million to Keelan and Siobhan and Retail Excellence for having me on. It's great to get a chance to introduce myself and Quinix and to talk about some of the workforce trends that we've seen. We work with over 800 customers globally. About 60-70% of them are in the retail space. So we get the hindsight of talking with these customers in different regions, different parts of retail, and are able to see the kind of the trends that they're seeing as we come out of this kind of pandemic. So Quinix in a nutshell, we're a workforce management and optimization software. And we kind of typically help our customers in three kind of key areas. If we think about what drives a schedule, particularly for a retailer, we can look at kind of KPIs like sales, footfall, unit transactions. These kind of drivers that are ultimately going to create an optimal schedule. And what we want to do is to make sure that we understand these drivers to create a better forecast and an optimal budget, creating an optimal schedule. So making sure the schedule is as cost effective as possible. So when we think of those peaks and troughs in any given day for a retailer, to make sure we've got the right amount of people when the footfall is higher, to make sure we're converting that footfall into transactions, and of course in times when it's kind of less busy, to make sure that we're not overstaffed, resulting in unnecessary staffing costs. And of course that's changed hugely over the last kind of 12 to 18 months, and we need to be ready and be flexible to deal with these new forecasts as we move forward. The other piece is around performance, and that's probably talking about that trough that I mentioned. Making sure that the customer service that employees provide is as good as possible, the right number of people to deal with the customers that are coming into a store, and making sure that your service level agreements and the customer service stays at a high for you. The third piece, and this is what I kind of want to touch on and dive into a little bit deeper in some of the trends that we've identified over the last really 9 months, examining sort of over 400,000 schedules, and that's happiness. The deskless workforce in retail, and I'm conscious we'll have people on the call from all different parts of retail, some who are not open, who are dealing with furlough, and then others who are in the essential parts of retail and our pharmacy kind of customers who are other challenges. But happiness is a key one, and that really for the deskless retail workforce is looking at the flexibility, the visibility around their schedules. So I don't think anyone can kind of argue really that the world is changing, and we've broken it down to kind of the three key areas that we see how it's changed for retailers. So changes in societal and buying behaviors. Everyone is hugely conscious of where transactions are happening, where decisions are happening. Is it in store? Is it online? And omni-channel is key. But for bricks and mortar retail, and again, depending on what part of retail a customer is, the tasks, the jobs, the responsibilities that your employees have in store are likely to change. And they need to adapt and shift with the changing in these buying behaviors. We look at, fashion retail, and we're seeing, being open in the US, starting to reopen in the UK, and opening in Asia. It's much lower footfall still that we're seeing, but retailers are seeing higher conversion rates in terms of those transactions. So skills around sales and customer service are going to be key. When I think of, the essential retailers, and pharmacy is a good example, changing hugely. Pharmacy before, looking at prescriptions being a massive part, and still is a part of their business. But those other, clinical services, which has been spurred on, of course, by the COVID jab, what else can the pharmacist now do to support the HSE and the global healthcare systems? Health and well-being is probably more important than ever. And again, I look at, the retailers, the ones who are not open, the ones who are open is going to be quite different. We've got employees furloughed or maybe now unemployed, are going to have very different issue to the essential workers who are going to be working on the front lines, who are going to need that extra support as well, to make sure that they feel safe in doing their job. And two really different and complex scenarios that HR professionals now have to look at as we start to come out of COVID-19. And then finally, the new regulations occurring in all sectors. We're probably yet to see all of these, whether that's from global government level or new rules and regulations around cleaning, that your own kind of own policies that are coming down as well. We need to be aware that, first of all, we're compliant with these news and these new rules and regulations that come in, but they're there to keep employees safe and make them feel safe and secure so that they can do their job as best they possibly can. So the state of workforce operations, and this is where we've dived into, all of our customers across retail, looking at essential, non-essential, those that are open, those that are not open. And I've been able to get some kind of good statistics from these. So if we look at the ones who have been open, and both essential, non-essential, more sort of in Asia and the US as well, 30% more labor costs due to bad schedules. It's very kind of tough to react in this market, to kind of gauge, when are we going to see those peaks in footfalls? When are we going to see that time when we need to be converting this footfall into transactions? And by having these schedules either greatly overstaffed, which is reducing in that unnecessary labor cost, or of course understaffed, which is reducing in those lost sales, those lost opportunities, and ultimately affecting your customer service. And the third point there really is around those labor laws on a weekly basis. Store managers in particularly, and HR, have so much to do to get retail back opening safely, and those that are not open, of course, and the ones that are open, is to continue operating safely. And they don't want to be looking at schedules where are they concerned that are we violating certain labor laws. It's another burden that they don't want to be looking at. It's another burden that should be taken care of by technology, so that HR's time can be spent strategically looking at how to keep employees safe and engaged as we kind of come out of this. Just two interesting numbers that I kind of want to share with you. So when we looked at these sort of 800 plus customers and looked across those 400,000 schedules that I mentioned, there's a couple of numbers that I thought were very interesting that came up and kind of show us where we're going and some of the things we need to take into consideration as we look at the future of the retail workforce. 20% of deskless workers say that they have gone into work sick during the COVID-19 pandemic. And why would a retail worker kind of do this? And there's a couple of reasons that came out. One was pay. They needed to do that shift to make sure that they could pay bills and look after their financial responsibilities. The other big reason that came out was that they felt that it would reflect badly on them if they didn't cover that shift, or they couldn't find someone else to cover for them. And that level of flexibility needs to be there. We've seen, as workers at a desk, we're all working remotely now. I think we'd love to be doing this live, but that won't be for the foreseeable future. And we've seen that flexibility working remotely. Of course, the deskless and the retail workers can't do that, but where is the flexibility going to lie? And that lies around the types of shifts, when they're working, swapping shifts, and looking at more ways that they can work sort of part-time hours and shifts. The second number that I want to share is really around 32% of domestic workers, which is flexibility over money. And that was a really, really interesting one. And again, we looked at these employees who are in stores across essential and non-essential retail. And we've seen it's hugely interesting. In certain parts of retail, there is a battle for talent. And it looks like, as kind of country by country and region by region, more non-essential retail opens up, footfall continues to kind of increase in essential retail, that there will be this war for talent in retail. And flexibility is hugely important at this. So being able to offer that level of flexibility and that level of visibility is a real bonus in terms of recruiting the right people and, of course, keeping the right people in terms of retail. And kind of really just to finish up on that point, to be able to do this and offer this flexibility, it can't come at a cost to the business. It has to make sense. And as we look at the trends in terms of footfall, the new opening hours that we're seeing, particularly in the US and Asia, we look at shift patterns. They're changing and changing and changing. They're not these 8-hour blocks that we used to traditionally see. This ties in quite nicely with the level of flexibility that employees are looking for. So again, if you've got that flexible workforce, you've got the shift patterns that encourage that, and you can bring that all together to make sure that as a business, you're optimally scheduling. For your employees, they're happy because they see their schedules in advance and they know they have that element of flexibility. That's where it becomes a real win-win. So meeting that business optimization and that employee flexibility part. And it's interesting when we look at sort of where the VC funding is coming from in terms of HR, finance, ERP software, very small percentage of it is actually looking at the deskless workforce. And that's really where Quinix, we're trying to make that difference. It's giving that business, if we go back to the kind of the 3 points that I started with at the beginning, making sure the schedules are optimal in that they're as cost efficient as possible, providing the best customer service as possible, but also keeping your employees as happy as possible. And that's really where we see the future of the retail workforce. That's all for me. So I'll hand back to Keelan, and I'm happy to take any questions there towards the end.
Great. Thanks, Ken. That was quite interesting. I think the key point there is to just consider your employee experience as well as your customer experience, especially now while you're closed. Could be a good opportunity to review how you do things and evolve. So yeah, very interesting. Thanks, Ken. Over to Tommy Smith there now, and we'll let Tommy share his slides in a second. Ken will knock you off there. Looking good, Tommy. Yeah, looking good.
Good to go. You can hear me, Keelan, and everybody?
Yeah, perfect.
Good stuff. Okay, well, thanks, Ken, for that, and good afternoon, everybody. I think Tommy Smith is my name. I'm a HR consultant, and since 2007, our consultancy has partnered with Retail Excellence for HR, employment law, and industrial relations advice. And happily, I'm no expert on webinars, but we've done a few over the last 12 months for our members, and they've gone pretty well. It's always dangerous though when Retail Excellence leave me choose the topics. So I think my natural debate in my head is, do I kind of do a deeper dive on one or two issues, or do I try to introduce you guys to kind of a suite of issues that are relevant at the moment? And as I normally do, I've gone for the latter. So look, I'm going to try and get through 6 or 7 different issues that are topical at the moment, both for pandemic related reasons and also just coming at you, charging at us down the tracks reasons. So I'm going to be very disciplined and very good on time, because I'm going to be the #1 keen listener to Robert's piece in a while on face masks, because even from our own HR office, we're seeing it's coming up quite commonly now. So it's a very interesting and important aspect for you guys to know. So we'll crack on. So the first few, I'm gonna introduce kind of our more pandemic-related discussion points. And I swear I didn't know what Ken was going to talk about a while ago, but actually he struck a few chords as he was going through with some issues that I'm going to talk about. So the whole concept of flexible working, you know, I suppose it is something that's come to the fore because of the pandemic in the last 12 months, but it's actually something that was going to come up as well in the near future anyway. So first point really in terms of home and remote working, and look, two things. I know you could say I'm a year late in bringing this to the table now because a lot of people have been working at home for a year, is a fair point. And the second one is I understand as well for the, as Ken would have said, the deskless people who work in retail, it's not the most relevant of points, but still, as retail businesses, you could still have HR departments, finance departments, marketing departments, and what like, and requests to work from home or currently working from home are relevant. And also, when the pandemic disappears, you know, the concept of home working or remote working isn't going to disappear. I think that's pretty clear at this stage. So maybe employers are going to start formalizing policies around that more. And I suppose just as a quick checklist for things that you guys should be paying attention to in contemplating a more formal arrangement of working from home, it's, you know, childcare would be one. I mean, again, employees are in essence working from home, so you would still have an expectation, or the employer could have an expectation that that there is still childcare in place, that they're not looking after 3 kids as well as trying to work for you guys. Connectivity is another issue to discuss in any preparation for our working from home agreement. Again, where does the employee live? Mobile phone signal, broadband signal. A risk assessment is one which probably people got a free pass on for the first few months of the pandemic before kind of, right, it's time to start taking this seriously now, because I mean, in essence, spare bedrooms, kitchen tables, converted garages have become an extension of the workplace in the last year or so, and risks and hazards that exist there have to be addressed by the employer under your obligations under safety law. You know, ergonomically, a person sitting at a poorly designed kitchen table with their laptop and kitchen chair for 8 hours a day may not be the best for their back. So stuff like that has to be addressed in a proper risk assessment document. There's good templates on the Health and Safety Authority website as a starting point for people. And moving on from that, in terms of insurance, look, we can all flick on our phones and see on Facebook feeds or the journal feeds or such like, you know, articles about awards and insurance claims that probably, you know, get more and more incredulous as you go on. But, you know, I'm sure Robert will agree when he, you know, it's not that far away from someone being on a work call at home and slipping on a child's toy walking down the stairs and trying to label that a workplace accident. You know, that's not an absurd consideration. So I suppose in line with health and safety, to make sure your insurance covers the likes of working from home and remote working is important as well. GDPR, well, look, I mean, I think we'd like to think there's not too many visitors to our home working employees' homes at the moment, but again, going forward in the future, the nosy neighbour pops over for a quick cup of tea while your employee's working at the kitchen table, and all these legal papers or you know, important employee files or whatever are spread out. You just need to be conscious that anybody who does bring any work home with them or accesses the employer or server is conscious of their obligations of confidentiality and GDPR. Working time. So look, again, just because somebody's working from home doesn't mean you don't have obligations under the Organisation of Working Time Act to make sure you can keep a record of their start, finish and break times. So there's apps, you could do it, there's an array of ways you can do it, but you still have to consider it. It's not something to be forgotten about. And utility bills. So again, you know, the question has come up there, if an employee is all of a sudden blasting the heating for the last year at home when they wouldn't have ordinarily during the day because you need them to work from home, is there a contribution from the employer for that? Likewise, the likes of broadband or an upgrade of broadband to a more expensive package. I think this is something you could also ask your finance or your accounts department. There are employees can claim rebates, I think up to €15 a week from their tax for this. So if you're not prepared to make any kind of contribution yourselves towards it, certainly you could assist the employee claim any VAT back or tax back themselves on it. So I suppose moving on from the working from home topic are 2 EU directives that have been out there anyway. Maybe they've been accelerated because of the pandemic, but there certainly have been there. And one is this directive on work-life balance, okay, that the EU has introduced, generally for parents of children up to 8. Now, there's 2 key facets to it, leave and flexibility. On the leave side of it, Ireland has been pretty good, been ahead of the curve in terms of parental leave, paternity leave, parents leave, etc. On the flexibility side of it, we probably haven't been as good. Employers have been expected to rely on off their own. The carrot has been dangled, let's say, encouraging employers maybe to show flexibility for employees. That's going to strengthen into more of a stick instead of a carrot now, when more regulations are brought in this regard. And it's really going to give, look, it comes from an honourable place. It comes from a place where parents, primarily mothers, if we're honest, you know, when they have young kids, are more often than not forced to take a break from the workforce, take a break from their career, and can find it hard to get back to that level when they would go to resume a career afterwards. So it's really bringing in a more kind of a stick approach to the employer, where there's an expectation that you do show flexibility in terms of differing work hours, shortening of work days, varied responsibilities, work from home, to provide for parents of young children. Slightly as a counterpoint to that then is another kind of EU directive, which has been sniffing around since 2003, I think, but has really only come to the fore in Ireland because of a legal case involving KEPAC and O'Hara a couple of years ago, where Miss O'Hara was kind of at executive level in KEPAC and, you know, kept getting emails out of hours, had no ability to switch off. That was counted as working time, which meant, you know, her working hours and her rest breaks weren't as such, and she got 7,500 compensation. So I suppose, look, in a retail environment, possibly you guys listening to me, or, you know, your managers or your HR team or your ops team, everyone gets phone calls on their day off about the alarm going off, or about where's that order, or we're missing something, or what do you have to do? And I suppose you just have to be careful about that now going forward, and bring in an actual policy on a person's right to disconnect from work. You know, years ago, I remember as 2002 and 3, when I was still failing as an engineer before I'm doing this now, you know, there was no email on the phone. So you came in the morning at 8:30 or whatever, you turned on to find any emails that came in overnight. Now there's a slight glow on the bedside locker at 11:30, and you know someone's been on to you about something. So I suppose, look, practical tips on that are, try to avoid people using personal devices for work. Try to, if they need a work phone, give them a work phone, which can be turned off. If they need you need to contact them by email, give them a work email that doesn't mingle in with their personal one. Okay. So again, that's a policy that's possibly coming down the line in terms of employers having to actually develop this right to disconnect policy. So I think the learning from this particular point is there's going to be an expectation on employers to provide more and more flexibility that is just coming down the line. You know, the definition is you have to act as a reasonable employer, but especially with the flexibility and the work-life balance one, the bar for what's reasonable or not is going to move in the employee's favour soon, and we have to be ready for that. In terms of HR, I think again I'm gonna comment on something kind of Ken said there, where he said, you know, that, you know, HR really should focus on things like culture or personal development of people, or the battle for talent, and becoming an employer of choice. So that really HR can be supported now for the transactional stuff it does, like rotas and rosters in Ken's case, and other things as well, to technology embrace it now. So I think it's been on an upward curve of technology usage over the last few years, of course, but I think the pandemic again has caused a bit of a seismic jump in that curve. So, you know, like we're on a webinar today, as Ken said, we could have been having this session in person if it wasn't for the pandemic. And also we all have new apps on our phone now: Teams, Skype, Zoom, and Google Meets. And, you know, certainly we in the last year or so have been doing, you know, I think Robert in Sherwin O'Riordan will say he's been doing kind of employment law cases, as well as we have remotely over the last year, as well as disciplinary meetings, as well as employment grievances, as well as investigation meetings. But also employers have been doing interviews far more than before, employment appraisals, general meetings with their employees. And we would say, like, that's grand. When the pandemic's over, that may drop off. But if you found that good, if that has saved you guys time and expenses, without a huge drop off in quality of interaction, it's certainly something to continue with. I think in terms of, again, HR systems, that can help you with everything from recruitment and screening of CVs automatically to roster preparation and document control and file management. So document control, you're giving your handbook, giving your safety statement, giving your induction pack to employees, can be done online with the likes of a DocuSign mechanism now, instead of having to continue to kill trees and print reams of it and hope the manager remembers to hand out the copy to get signed and get back again. HR file access again, you know, via technology. You can certainly make sure that we won't mention GDPR. We'll presume GDPR is all fine, but that, you know, management and ops and HR can all access a person's HR file remotely now. Filling in of forms again, surveys, exit forms, you know, pre-recruitment questionnaires, they can all be done remotely. Embrace technology to save you guys time. It's something that's just taken another leap forward with the pandemic. And what I would say though is make sure your internal documents catch up with it. So if you now are going to use the likes of online meetings for investigations or grievances, just make sure you reference that in your terms and conditions of employment. Where necessary, address your handbook, address the relevant policy, and include for the use of online systems. Look, I think as a general comment, I think society thankfully has changed attitudes towards mental health issues, particularly in the last 10 years. If I think back to even to my teenage years in the mid-90s, if a student mentioned the likes of anxiety over a variety of things, they certainly didn't get the sympathetic ear, thankfully, they're getting nowadays. And I think secondly, then it's universally accepted, guys, that the last year has just been immensely tough on everybody in many ways. Whether someone's out on the PUP payment and isn't working, or whether somebody is in work and coming in on public transport to a COVID workplace, it's been tough on everybody. Okay. What I would say is I think an employer probably needs to go beyond, just kind of paying homage to that in a policy related way. And I'm going to liken this certainly to dignity at work, because I've noticed a shift in Labour Court or WRC decisions on the likes of dignity at work. Previously, for an employer to say, oh yeah, we take something seriously, we have a policy, sure, isn't it addressed in the handbook? Was sometimes a reasonable defence an employer could rely on. I think that's moving now. It's not just about what you've written in a document and left there. You actually have to prove it by what you do all the time. So I think as well as having the likes of an employee assistance program for your team now, which is generally provided by the insurers out there, VHI, LEA, they have these ones as well as other private ones, just provides information and the counselling support for your employees should they need it. I think employers need to move on a level beyond that as well. That's more reactionary. I think employers need to try to become proactive now and maybe train your line managers in understanding mental health considerations of their team, and even bring in wellness initiatives proactively. Okay, so things like kind of your social supports, your social club, eating and wellness tips, and bike to work schemes, mindfulness sessions with outside contractors, webinars such as this, and even charity work. Just get involved and be proactive in things that feel good and that are good for your staff. So again, your staff are your assets of your business. You rely on them to sell your products, okay, and ultimately make you money. So there's commercial sense as well as moral sense to make sure that your team are looked after. Okay, vaccine rollout, and I'm going to be unapologetically grey in this area. I know consultants can get a reputation for not getting a black and white answer, but look, there's a bit to go yet before we really see kind of how far employers can push kind of vaccines. I think the basics of where I am looking at it for now is there is no legislation making a vaccine mandatory, and a person has an individual constitutional right to bodily integrity. So you can certainly encourage employees to take it, but you can't compel them to take it. I think, again, everything goes back to logic and everything goes back to a risk assessment, really, okay, where you can sit down logically, look at an employee's role, look at the associated risks, as I presume everyone has already done while you've been reopening, while you've been preparing for the work safety protocols that are actually there now. So at the moment, a person could be working in a customer-facing role when there's a certain footfall through their shop. If they don't want to get vaccinated, but movement of people starts to increase, if there's a higher footfall as the population comes back into shops and things get busier, one could argue that their risk increases. While at the same side, other employees who did get the vaccine have mitigated their risk. So perhaps down the line, it may be possible for you to sit with an employee and explain why they're now further at risk compared to their colleagues by choosing not to get the vaccine. Okay. Hopefully there will be more guidance from the government on this. Hopefully there will be more guidance from the Health and Safety Authority, and that kind of you're not kind of making such decisions or recommendations in a vacuum. I think certainly what I would have in mind is, you know, save off a document and start creating a vaccination policy. Okay, that kind of starts with a logical basis for kind of what may happen if a person decides not to get the vaccine. Okay, I think just be conscious and be very careful to presume that it's okay for you to take whatever negative steps against an employee you feel is reasonable. It has to be logic based. You could possibly look at working from home for them. You could possibly look at less customer facing hours or different roles because of their health and safety. But I think in making those decisions, it has to be paced out and follow the logical risk assessment style approach. Pardon me, try to get this working again.
Just try it one more time, Tommy.
Oh yeah, I got it there now. Sorry. So good guys, a few further points I'm gonna do. I think I'm okay for time for once, thankfully. I'm just going to talk about some things that are coming down the line, possibly or definitely. So mandatory sick pay. So late last year, we assisted Retail Excellence preparing their submission on this notion of sick pay being brought in on a legislative footing, that all employers in Ireland would have to give sick pay to their employees. And if a Fine Gael Tánaiste seems quite keen on it, you know, really that's the flag being flown that it's probably going to be coming in, all right, guys, okay? I think what's important is certainly, look, you know, whenever sick pay is mentioned on calls with my clients, it seems to have an overriding negative kind of reaction. And I suppose, look, I'm a 1%er guy. Most people tend to ring me about the 1% of problems, not the 99% of employees that cause them no problems and stuff. So it's important to realize that, you know, Ken also mentioned a stat there a while ago that 20% of people came in when they were sick, you know, during COVID, and like the fear of not getting money, the fear of not being able to pay bills was a big part of that. So this is something where it's encouraging employers to contribute towards employees to sickness, you know, in a structured way, in a limited way, but at least that means that good employees, the 99% of good employees of yours who get sick, who need a bit of support, you're there for them, okay? So what I would say is a tip to have as well as an occupational health team on call. Because obviously if you're now going to be forking out for sick pay, to get some advice or to get some support or to have an appointment available with a nurse or an occupational doctor or something, it's always good for you to develop like your friendly HR consultant, your lawyer, your accountant. Really having a company doctor on standby is something I would recommend having. And I would also recommend to keep an eye on your absence management policy, okay? Because if and when mandatory sick pay is going to be brought in, there are going to be other conditions attached to it which are in the employer's favour. So things that are going to be referenced could be, when does sick pay kick in? There's probably going to be a waiting day of 1, 2 or 3 unpaid days before sick pay is then allowed. What amount of sick pay are you then going to have to pay? And hopefully the government will bring back the social welfare qualifying time from 6 days back to coincide with when an employer would have to make a contribution. So the employer would merely be paying in conjunction with social welfare as well. There may also be a qualifying period for when employees would get it. So an employee just in the door a week or two may have to wait 6 months or 12 months or go past probation before they'd be entitled to sick pay under this scheme. So there are other factors that will come in that would lead to you maybe needing to update your absence management policy later in the year. So I suppose, in short, it is happening. It's fairly safe to say that there is going to be sick pay brought in at the statutory level. It's going to cost you money. So I suppose look at it in a positive light, look at it as you rewarding the good staff. And I suppose let's look at the fine print when it's published and maybe redesign your absence management policies accordingly to make sure we're all up to speed and employees know exactly how they have to go about claiming this sick pay from you. So I'm not going to spend a huge amount of time on redundancies. It's something I have brought up in the last webinar, so it's not something I like talking about for fun. It's something I suppose I still want you guys have in the forefront of your mind. So at the moment, there's still a protection for relevant employees against claims from it. So let's say pubs and non-essential retail who are still closed, you know, your employees can't quite knock on your door and demand redundancy from you. It isn't sustainable forever. So when you do reopen, it's highly likely that that protection is going to be removed. So I think what we're then moving on to is, well, what happens when you reopen? How will the economy be? How will demand be? There may be an initial wave of demand while pent-up savings get spent, but what's the economic conditions going to be at that stage? And I suppose the really initial headlines I try to get you guys to remember is that, first of all, you're making a role redundant, not a person redundant. Okay. And second of all, if anyone does end up being made redundant because their role is gone, you're firing them, you're terminating them, you're dismissing them. And therefore it has to be done in both, the decision for it to be them has to be credible. And also you have to follow a pretty robust procedure to make sure it's fair in how you went about identifying redundancies, and then the selection criteria that ended up selecting that person. Okay, if you're looking at kind of costs or budgets, you can use an online calculator on the social welfare website, which you can input some data and get a statutory redundancy cost. All right, so really, the thing is, you don't have to remember anything other than remember that Tommy said redundancies are dismissals, so just be careful doing it. That's all you need to remember for now on it, okay? So if you do have to consider it later in the year, just remember to plan properly. Don't get some advice, and we can help you in making sure that you follow the process that needs to be followed and end up with the right decision. And finally, I'm going to bring up kind of another chestnut that's kind of seems to be doing the rounds at the moment, and it's just very relevant now and is going to be relevant for a few years. I've lumped retirement and pensions kind of into one, because I think when I had them in 2 slides, there was a bit of repetition going on. So the first question is, what's your retirement age and why? And whenever a client asks that, they think it's 65 or 66, and they kind of puff their cheeks out and don't really know why. Think maybe that was what was on the document when they poached it from their buddy in the business down the road. But I think they probably end up coming along to the fact that it was 66, 65 because that was the pension age, wasn't it? And if you say, well, yeah, the pension age has moved to 66 now, and it's going to increase. It was going to be 67 until the last election, when the political parties were forced to postpone that. All right, so it's moving to 68, and the retirement age in the public service now has moved up to 70. So retirement ages are going one way. And if you want to stick to a lower retirement age, you have to objectively justify it. And this is again set out, right, that it can be on the likes of safety grounds, or to provide promotion opportunities to a younger demographic who you feel you may lose if they don't progress, or to provide an age balance and skills mix. But they're a bit wishy-washy, guys. What you need to be careful in retail is, like the guards and the army, or a coal miner, or certain construction jobs, you can probably sit down and objectively justify on safety grounds how a person of a certain age profile may not be insurable or may not be safe to work in those roles. But selling products in a shop, you just have to be very careful to try to stick to something like 65 or 66. And in reality, those days are gone, and employers have to realize that now, that if you think you can kind of just approach somebody at 65 and say, sorry, you're tired, goodbye, then I'd encourage you to just Google RTE and the legal cases they've had about retirement ages, and see the 100 grand that they got awarded last year when they tried to, against them last year, when they tried to enforce a 65 retirement policy. Okay, so just be very careful, have a look at your retirement policy, have a bit of an internal debate as to why and how it is what it is, and we're here to talk further if you need us to. In terms of pensions then, all right, part of the reason, again, maybe why there's a pressure on retirement ages going up is financial. And I think, how's the way I found to say this to people? I don't know, but it used to be the case that you did retire at 65, got your state pension, but you probably died at 75, all right? And I think because people are living healthier lives, maybe, because there's better medicine around, because we have less manual labour possibly in Ireland than ever before, people are living longer. And so the people who decided on what's a fair amount to give somebody as a state pension in their life after they retire, those figures have gone through the roof now. And basically you have a state pension from when you retire, when you reach the age until you die, and basically the country can't afford it anymore. So number one, people should be encouraged to stay and work longer before they maybe would avail of pensions. And number two, they're now recalibrating who and what contributes to pensions. So this auto-enrollment scheme was due to start next year, where it's a combination of the state, the employee themselves, and also you as employers will be contributing to employees' pensions. And this is happening. It was going to be starting next year, but I get the feeling that's going to be delayed now, and it's going to be another year or two, partially COVID, partially the government can't sort themselves out on it. All right, so it is happening, okay? So I suppose, I just think the learnings on that are, in terms of communication, do not, if you think your retirement age is 65 or 66 at the moment, do not wait until a week before the person's birthday and say, oh, what are you up to after next weekend? You need to get in there with a very early intervention, 6 months out, and start a conversation with them about what their plans are. And you need to have an internal look yourselves on what your policies are and decide kind of what are you going to do in terms of a retirement policy now, and how that would stand up to what's going on out there. And in terms of pension costs, look, it is coming. It's going to start off, well, the current, predictions are you're going to have to face a 1.5% starting levy as a pension contribution, but that's going to increase maybe up to about 6% as a person hits 10 years with you. So it's not insignificant. So I suppose if you guys are ever looking at your medium-term wage budgets and wage increases and labour cost plans, it's something to factor into it. That kind of in a year or two's time, something circa 1.5–2% is going to be mandated on you, as well as this sick pay increase. So that's the reason why I want to bring these in. That if you ever are looking at wage budgets, you've got to factor in the likes of these costs now as well. So again, like the pension ratio now is about 5:1, and by the time we hit 2050, that's going to be 2:1. Okay, but there's going to be again a lot of small prints, and again we'll keep on top of that with you over the next while. So I suppose as a summary, again, I probably appreciate you guys are going to say, God, because any one of those topics, guys, I could continue talking for half an hour. All right, so I think, look, I wanted to just open a line of conversation with you on them. We're also speaking in the upcoming events of the Management Development Programme, an excellent programme for your managers. We're also going to talk at the REI, the Retail Summit, coming up later in the year, and not too dissimilar a topic. And obviously all of you guys as members, you have 3 complimentary hours support with us. So if there's anything from today you want to address with us, we're more than happy to deep dive a bit further, or again, talk about how those issues may, in a personal way, relate to your business. So thank you, and keep in touch.
Thanks, Tommy. Plenty food for thought there. That's great. A couple of questions we'll hopefully get to at the end. Just one sec there now, and we'll let Robert, you share your screen. Great. Tommy will mute you.
It's going to go back.
Yeah.
Okay.
Super.
You can see me all and hear me all.
Yeah, perfect, Robert. Thanks.
Okay. Thanks, Keelan. My name's Robert Dooney. I'm a solicitor with Sherwin & Reardon Solicitors. I practice predominantly in employment and in litigation. I'm obviously here today to talk about face covering and the regulations imposed last August, to deal or to address the issues surrounding face covering. It's really become quite a hot topic over the last number of months, and unfortunately for business owners, it's also become quite litigious. And I guess to compound the stresses and anxiety being experienced by business owners of late, they now have this issue about face covering to contend with. There are some ways in which business owners can deal with it. Some prefer not to confront customers who come onto their premises and refuse to wear face covering, and instead they might put up notices or run tannoy announcements regularly in their premises. There are other business owners who do prefer to confront rather than not confront customers, and in those cases you might find that the customers would become quite, I guess, belligerent, and as they're leaving the store or the business, they might threaten litigation against the business owners, and usually they might refer to pieces of legislation such as the Equal Status Act. The purpose of this talk is really to go through the basis of that claim, and I guess to tease out if there's any legal basis to it. Unfortunately, it's an issue which hasn't really been tested too much by both the Workplace Relations Commission and the civil courts. Now, the Workplace Relations Commission does deal with these sort of complaints, notwithstanding the fact that the customers are obviously not employees of the various businesses that they might go into, but that the WRC does in fact deal with them. The civil courts, such as the district court, they would listen to complaints of this type if there's a liquor license on the premises. I just think that once decisions are issued by either the WRC or the civil courts, that it will eventually, in my view, act as a form of deterrent against some potential litigants who feel quite aggrieved of being asked by business owners to leave the premises because they refuse to put on a face covering. Now, whether or not it does act as a deterrent will obviously depend if those decisions have been published or not. But we'll just have to wait and see. This talk is going to not only focus on this regulation, which you see here on this slide, but also it's going to deal with the Equal Status Act, as well as other pieces of legislation, which I think should be borne in mind by businesses who have to meet, I guess, complaints or claims made by customers. And by that, what I mean is that they should refer to these various pieces of legislation, which I'll mention in a few minutes, by way of demonstrating that they also have obligations to other people who might be on the premises at the time that this non-compliant customer arrives. You'll see there that this regulation 4.1, it's an amendment of the Health Act of 1947. It was brought in, as I said, in August of last year to deal with face coverings. Unlike the Equal Status Act of 2000, which is a very good piece, well-drafted piece of legislation, this regulation 296 of 2020, it's leaving open a lot of issues. It's left them open for interpretation. And I think that's where a lot of confusion arises and a lot of discomfort for business owners. It would have been best if a number of issues raised in the regulation, such as the one that you see in front of you, such as reasonable excuse, and would have been sort of more, I guess, defined better. But you'll see there that a person should not, without reasonable excuse, enter or remain on the relevant premises in a relevant geographic location without wearing a face covering. Just to deal with reasonable excuse, and you see that it's defined under the regulations as a situation where a customer comes onto the premises and decides that because of a physical or mental illness or impairment or disability, they can't put on a face covering, and they certainly in their own mind can't do so without suffering some form of severe distress. It doesn't, under the regulations, it doesn't go into specifics as to what constitutes mental illness, impairment, or severe distress, and that's quite an issue for both the customer and business, because the customer will be looking at this and will see the word severe distress and may not know what it means, but might decide, well, that's an excuse I can make for not having to wear this face covering, and a complaint might all of a sudden go into the Workplace Relations Commission against the business, and the business is obviously faced with the legal costs of having to challenge or contest that particular claim. So another reasonable excuse will be to remove the face covering in order to assist someone in an emergency or to avoid harm or injury, the risk of harm or injury. And you see the other three excuses there. Just it mentions responsible person, which I'll talk about in a second. And the last one is at the request of the responsible person. The person removes it to allow workers or responsible person to provide healthcare advice to that person. So that's the relevant premises, and it was tweaked more recently. It was limited, if you remember, just before Christmas, and the transmission rate shot up before Christmas, which was expected, and therefore it was broadened out against this issue about the definition of relevant premises. This also was amended, and just, I mean, they're obviously keen to amend it as they go along, but I think the amendments could have been made or directed or targeted towards other aspects of the regulation to try and minimize litigation against business owners, but they didn't obviously seize that opportunity. Without leaving a visible gap was a new addition to the definition of face covering. And this is a responsible person definition. And it says the occupier of the relevant premises, the manager of the relevant premises, and any other person for the time being in charge. The person for the time being in charge, that could easily be a staff member who has just been told by their boss to look after the place while they're gone. And again, it leaves it open for interpretation, and these issues will have to be dealt with, probed, and decided upon by the tribunals and the courts before more clarification is given. But it's a shame that they haven't seized the chance to do it in either the first or second draft or amongst the various amendments, in order to avoid businesses like yourselves having to possibly meet complaints before the Workplace Relations Commission. And these, in my view, are, just as I mentioned before, these are the main pieces of legislation which a responsible person can rely on when informing or promoting face covering protocol. But this list would obviously be in addition to the regulation itself. And what's interesting is at the core of the regulation is the fact that it was implemented in the public interest. And if you read the preamble or introduction to this face covering regulation, you'll see that the minister states that in the exercise of the powers conferred on me by sections 5 and 31A, inserted by section 10 of the Health, Preservation and Protection of Other Emergency Measures in the Public Interest Act 2020. And he goes on and says, preamble states that having regard to the immediate, exceptional, and manifest risk posed to human life and public health by the spread of COVID-19. And for me, that's really front and center of a potential defense that you might have. Now, I know that if you're defending litigation, it means that you're obviously forking out money to do it, but that's unfortunately, that's the reality of what could happen. We don't have a system in Ireland which you might have in the States, where in some situations you might have to get leave of the court before you can bring claims such as this one arising from a breach of the regulation. So over here, a potential complainant can simply go online, fill out a complaint form, submit it against the business that they've just been asked to leave because they weren't wearing a face covering. And then in a few months' time, this business will receive notification of a hearing date, and they'll be required to engage somebody like myself to defend it. That's unfortunate, but it is the reality. the three other pieces of legislation is the Equal Status Act, the Safety, Health and Welfare Work Act 2005, and that act deals with obligations on employers to their staff members. Tommy mentioned it a few minutes ago, just in relation to working from home and what's going to happen if somebody suddenly trips and falls. Well, it could well be built into that act or become an amendment to that act to deal with a situation like that, because that act essentially deals with safe systems and safe places to work. And if the employer has to take sort of a positive step to ensure that that is complied with. So if someone does trip and fall at home, and if the amendment provides for it, well, that particular employer could be faced with maybe a personal injuries action. The other act is the Occupiers Liability Act of 1995. That deals with an occupier's duty to an entrant, such as a visitor, which would encompass, or a visitor for the purpose of that act, which would include the customer of a business. So just, I guess, in marked contrast to the absence really of a definition of what constitutes severe distress and mental illness and impairment under the regulations, you'll see under the Equal Status Acts that they've clearly defined what constitutes a disability, and it's set out there. So, I mean, there's no real dispute as to whether the person's purported disability fits squarely within the ambit of the Equal Status Acts if a case comes before the Workplace Relations Commission or comes before the district court, if the premises is subject to a liquor license, or even on appeal if it goes before the circuit court, that there's a distinct definition there, and you'll see what it says. Again, it's just, there was an opportunity for the people who drafted up the regulations just to avoid any confusion about what constitutes severe distress or mental impairment, but they didn't take that opportunity, unfortunately. The other issue is that if the customer comes onto the premises and if they say, or even if they present one of these self-declaration certs, which is, as the title suggests, it's not signed by a clinician, physician. It's signed by the person who, in most cases, will have no qualifications at all in medicine. So not an ability to be able to self-diagnose whatsoever, but they still present these signed self-declaration certs as somehow justifying the removal of their neglect, really, to put on a face covering. That's, I mean, when something like that happens at the material time, the customer doesn't need to be able to prove that they do in fact suffer from a disability. That is a disability that's defined under Section 2 of the Equal Status Act. That's something that they would have to, there's a duty on them, there's a burden of proof on them to show that at the hearing of the claim, either in the WRC or in the civil courts. You see that Section 4 of the Equal Status Act deals with discrimination on the grounds of disability. And you see that it's clearly set out there what that is, and in subsection 1, you see that it refers to special treatment, and that special treatment which a business could actually offer to the customer. Now, it goes on and it says in subsection 2, it refers to the refusal or failure to provide the special treatment or facilities, and it said that this can be justified in some cases where there's an unreasonable cost, not necessarily a nominal cost, to the business in question. My view is that special treatment for the purpose of section 4, subsection 1, could be an online service. For instance, if a customer comes into the business, refuses to take off, refuses to put on a face covering, and the business owner, the responsible person, approaches and says that unfortunately you'll have to leave if you're not going to comply with the face covering protocol. However, you can go onto our website and you can purchase goods or services if you wish. That could be deemed to be a special treatment. But if a court or tribunal decides that it's not, a strong argument could be made that the cost to the service provider, as referred to in subsection 2, that cost could be the risk of the health of staff members and other customers, and that would be dealt with under the Safety, Health and Welfare Work Act or the Occupiers Liability Act. Those are pieces of legislation that we mentioned in the last slide. Let's move on. This section 14 for me is it deals with certain measures or activities not prohibited. So not prohibited are not deemed to be discrimination. And this for me is the real trump card for businesses, that if they're faced with a situation that they've been sued by the customer for refusing to serve or refusing entry to the customer because that particular person won't put on a face covering, they should absolutely refer to this piece, to this provision in the Equal Status Act. Because if you see in the first point, it's basically said, it says nothing in the act should be construed as prohibiting, and it refers to any enactment or order of the court as an exemption to the respondent, really. So it's an excuse for the respondent or the business to treat differently a person who may or may not, or who claims to be suffering from a disability. And the reason in which they can do that is if they're simply complying with an enactment. And the face covering regulation is in effect an enactment. So if I were defending a claim brought against a business, my main line of defense would be this section, and you'd be waiving this section, subsection in front of the adjudication officer or the judge in the civil courts. And this deals with, section 38A deals with the burden of proof. And this goes back to what I said previously, is that while at the material time in the store on the day, there's not an onus on the customer to demonstrate that they were suffering from a disability. That onus takes place later on at hearing, or even perhaps before there's an exchange of correspondence between both sides before a hearing, but usually at hearing. And that's a high hurdle to overcome, because while they might be able to get a claim off the ground in terms of putting in a complaint into the Workplace Relations Commission or issuing proceedings in the district court, the day will come, and that's usually at the hearing itself, that they'll have to show that at the time that they were suffering from a disability, and that's not sort of a that's not sort of a disability as in they were suffering from severe distress. They'll have to evidence that they were suffering from a disability as defined under the Equal Status Act, and that's the first point that they'll have to be able to show. And on top of that, they'll have to show that they were treated less favorably because of that disability, and evidence will have to be introduced. And from my dealings so far, it's the evidence that they'll have to be able to introduce is a difficulty for complainants, because businesses, a lot of businesses, if there's CCTV footage, they might wipe that after a certain period of time. So when it comes around to hearing, the footage will no longer be there. So the complainant is in this situation where if they went into the business themselves, it's a case that they're relying on their own evidence. And obviously they're going to try and present the best case possible themselves, but unless there's an independent witness is going to support what the complainant is saying, that they were simply asked that they'd disclose to the business owner that they were suffering from a disability. However, they were still told to get out. Unless they can show that they have an independent witness who's going to give evidence to that effect, it's unlikely they're going to get over that first hurdle of showing that they had this prima facie case. And I just think that, and again, this hasn't been tested too much yet, but when it is, it's difficult to see in those situations how the customer is going to get past it. And even if they do, again, the section 14 of the equal status, the business owner can just simply say, look, I was just complying with the face covering regulations. It's an enactment, and I was doing so in the public interest. And then on top of that, they can refer to their duties to employers and their duties to other customers under the Occupiers Liability Act. Now, in a hearing, the reality in a hearing is that the adjudication officer won't make a decision on that first point, whether the complainant has shown that they have a prima facie case. They will reserve judgment on it to allow the hearing proceed. And if they do manage to prove it, well, the burden shifts over to the business owner as the respondent to disprove it. But again, I think it's very difficult to see how they could actually get past that first step. It is the common duty of care, which is owed to customers or visitors under the Occupiers Liability Act. And if you see, the common duty requires business owners to be vigilant. Yeah. So this is, I mean, quite easily under this, one of the risks or dangers could arguably be the risk of transmission to other customers, or even to staff members. And occupiers under the Act itself, it's not only the owners of the premises themselves, it could be the leaseholders. You know, a lot of businesses will be leaseholders or tenants. So they would, for the purpose of the Act, they would also be an occupier. As I mentioned before, Section 8 deals with the duties of employers to ensure the safety, health, and welfare of his or her employees, and that's if it's breached, again, it could open a lot of I mean, it could give rise to a personal injuries action against the business. So all of these issues would be raised in defence of an action brought for failing to comply with the regulations. That you have to strike a balance between public interest, statutory obligations, and then faced with a situation how you deal with a person who comes into the store, comes into the business and refuses to comply with protocol, basic government protocol. And I think that the weight of obligations, it favours the business owners' duties towards staff members and other customers. And I just think it would take quite a cavalier approach by a judge or adjudication officer just to ignore all of that. It's difficult to see it. The options available, and just to conclude, the options available is that you just don't confront the customer, and you simply just put up notices at the signage or notices in the premises to inform or promote compliance with the regulations. But the risk with that, of course, is that other customers, they might complain about it while the person's still in the store. Staff members could contract COVID-19 as a result of that customer failing to comply. And then the business is faced with a situation where they've been sued by the staff members themselves under the legislation we've just mentioned. The second option is that you simply just confront the customer. And irrespective of whether or not to present a medical certificate or a self-declaration form, you tell the customer that unless they put it on, unless they abide by protocol, they'll have to leave the premises. And then the third thing is what I've mentioned already, is that you defend a claim of discrimination. And that sort of flows from point 2, but you defend a claim of discrimination from the customer by relying on those 3 pieces of legislation. So I'll hand it back to Keelan. If there's any questions at the end, I'll be happy to take them.
Thanks, Robert. That, in fairness, albeit it was very detailed, it was actually quite insightful there. Just we even find, retailers don't really know what to say to back themselves up. So we might even work on a bit of a wording there around the Section 4 and Section 14 of the Equal Status Act element. I think that was really insightful, that piece, even just as a bit of a backup for people. So appreciate that, Robert. Robert, just a quick question. I might just, while I have you, and then we will try and get back to everyone on the other questions. So is it okay to ask them for proof, and if they don't have proof of an exemption, it's okay to refuse them entry and say they can shop online with us? Would that be okay?
Yeah. I mean, it is. Now, I just think that it depends on the proof that's being given. I mean, if it's a self-declaration form, as I said, the customer might not be in a position to be able to self-diagnose. And then if you let them shop away in a store, for instance, that has other customers there, now albeit the social distancing might be complied with, but there is a risk. There is still a risk that transmission will take place. And that will give rise to liabilities under the other pieces of legislation I mentioned. It's really up to the business owner, but the business owner has to be cognizant of the fact that if they allow the person to move around the premises without a face covering, they run the risk of potential litigation from other customers or staff members. I know the risk might be low, but it's still a risk.
No, that's the big question. We even get it into the office. And just looking at the questions there, Robbie Woodcock from Cycle Superstore. Robert, I might just run this one by you. We have a number of customers saying they don't have to wear a face covering because they have been vaccinated. Is this a valid excuse, or what is defined as a valid evidence that they have been vaccinated?
Yeah, and again, I think this is something that business owners could be helped with by the government, really, because if someone's been vaccinated, they may not have any proof of that, and you could have a situation later on that they might be given vaccine passports by somehow to people who have had the second jab, to show that they are able to move around without any risk of transmitting it to somebody else. But I mean, if they can't show evidence, and if they don't wear the face covering, my view is that the business owner is still entitled to ask the person to leave, because it's not in the public interest that they remain on the premises.
Yeah, no, definitely. And then in terms of the evidence, ideally a doctor's cert or something of that nature really is what you're looking for.
Yeah, sure. It's simply just to eradicate any risk. And if they have a doctor, if they have a cert from a doctor declaring that they have got the second jab, that's fine. In my view,
Yeah,
that's
or any sort of disability or breathing difficulty or anything like that then as well, obviously.
Yeah, sure. I know in the UK that there's a large push on for women in particular who have been subject to domestic violence, and there's a huge push on there to exempt them from having to wear face coverings, because of the fact that it's obviously over their mouth, and there's a chance that they will be suffering from a lot of distress. So the organizations, the bodies over there that help these victims, they are putting together forms and that so they can carry around with them. And maybe it's a good idea for bodies over here to do the same thing.
And Rob, just one more is coming in there quickly. I presume the retailer can read that proof of evidence the customer is presenting to them. Is that okay to do?
It is that they can read it, so they're presented with a document and they're asked to read it.
Yeah, or they have the right to read it. They can ask the customer, can I read it? If they may be trying to bluff their way in or whatever.
Yeah, sure. I mean, absolutely. I mean, if they ask to read it and the person says no, well, and the person is asked to leave, well, that brings about another line of defense. But they can bring that up at the hearing itself. They can say, look, I just asked this person to read it, didn't allow me, so I was left with no alternative.
Sorry, Robert, just one more there. If someone shows they're exempt from face covering, but as a business owner, we ask them to leave, is this creating litigation?
So sorry, if someone shows up without wearing a face covering?
Yeah. If someone shows up that they are exempt from face covering, but as a business owner, we ask them to leave, will this create litigation? I presume if they can show you proof that they're exempt, that's fair enough. If not, then you ask them to shop online with you.
Yeah, sure. And again, it depends on the proof they can provide.
Yeah.
But I think the defense it's a strong defense for business owners, but it's them having to go to the trouble and cost of defending it, going into a hearing, and the stresses that go with that.
Yeah.
And there's obviously, it might affect insurance premiums, perhaps. And that.
Yeah. My good friend Mary Francis now, Robert, has one quick question as well, so I might just run it by you. Is it not possible that those vaccinated can carry the virus without symptoms, and so they could be deemed a risk?
I'm not a doctor, so I don't.
Yeah.
I don't really know.
Yeah.
But
No, that's fair.
yeah.
That could actually be an issue, though. All right, actually, yeah.
Well, I mean, if there's, let's assume that there is, and there's data out there to show that there is. Well, obviously they can transmit. So in those situations, they'll have to wear a face covering.
Yeah. That's true. Yeah, that's true. Okay, Robert, we might leave it there. I know we've gone slightly over. If there's any others, Sinead, I see you coming in there as well. I'll get that answered after, and I'll fire it on to you, Sinead. But thanks, Robert, for your presentation. Thanks, Tommy, for your presentation, and Ken earlier on. We'll get the video up on YouTube, and we'll get it circulated to members as well in the email update going out tomorrow. We also should have a piece in the Sunday Independent this weekend about our push for click and collect. So keep an eye out for that. And thanks for everyone for joining in. And we hope to see you all again shortly. Thanks very much, guys.